Welcome to Estate Planning Beyond the Binder.
Welcome to Estate Planning Beyond the Binder with Brian Chu, Managing Attorney at OC Wills and Trusts in Orange County, California. For more than 25 years, Brian has helped individuals and families create customized estate plans designed to protect their assets and provide clarity for the people they love. I'm Leanne Lyon, and today we are breaking down the real cost of probate in California. Hi, Brian. How are you today?
Good. Thank you for having me on.
Yeah. Hey, Brian, what does the probate process actually involve in California?
So probate is a court proceeding. And the purpose of the proceeding is to decide if somebody's passed on, who's in charge of the assets and how and when they're supposed to go to where they're supposed to go. And the issue with probate, especially in California, is it's very expensive and time-consuming. As you can imagine, anything involving attorneys, anything involving somebody having to go to court, they're going to charge tens of thousands of dollars of legal fees based on the value of the assets. And so probate, what happens if somebody, if somebody passes on, even with a valid will, and they own something like a house, okay? The issue there is let's say they have a house in Orange County, and that property's just in somebody's name. How do they know when that person's died? And how does the Orange County recorder know who's supposed to be in charge of that property after the owner dies? Okay, who can sell the property or transfer it? Well, that's what probate is. Probate is the transfer of control of assets from one person to another, and then ultimately to the ultimate destination, the heir. But the courts are going to oversee the process. All right. So usually what happens in that case, because the Orange County recorder will say, okay, even if there's a valid will, you want to be in charge, go to court, get a piece of paper saying you're in charge. And so that person will have to go to court. They're probably going to have to hire an attorney because they haven't been to court before, haven't been to probate court, don't know the procedures. They're probably going to have to hire an attorney. And that attorney is going to charge tens of thousands of dollars based on the gross value of the assets, which will be determined at a later date. And that attorney will file paperwork. And assuming nobody, and saying that let's say my parents have passed and we didn't do an estate plan for some reason, I would have to go to court, apply to be the probate, to be what's called the executor, and then they would file. My attorneys would open a case, and that will start a series of hearings. Okay, now for the most part, these hearings are probably going to be very simple. All right. But each hearing does give an opportunity for somebody to object to what I'm filing. The first one is, do they object to me being in charge? Do one of my siblings say they should be in charge? Right? And so we want to, avoid that. I don't want any fighting. I want to make sure, I just don't want to get involved in that. I just want to make our documents state who's in charge, and that person wants to be in charge, they're in charge. But probate's not like that. And so I don't want to get into too many details, but each point, they're going to ask, does anybody object to what you're trying to say? What is being filed? Whatever doc's being filed, does somebody object to it? And as a result, people have to be notified because once you file the case, your siblings and whoever else have to be notified. Hey, there's a proceeding. Do you have any objections? The creditors, they're going to have to get paid at some point. There'll be an opportunity for creditors, to submit their bills. And so this is all a long, drawn out process. And we're going to talk about this later. You miss deadlines, people signing off, and it's going to make the process longer.
So how does California calculate those probate fees, and what surprises people about the way that those fees are structured?
Probate in California is not necessarily more expensive just because it's California. Our fees are more expensive because our properties are more expensive. Okay. A lot of people don't realize how, especially if their families own the property, their parents own the property 10, 20, 30 years, how much that property's gone up in value. And the probate fees are based on the gross value of the assets that are being probated, which typically, again, is the minimum of the house, if that's what's being probated, could include a business, if there's a business owned by somebody, and maybe the financial assets to the extent that you didn't name any beneficiary on those accounts, like a lot of people on checking and savings especially don't have any beneficiaries on those accounts, or B, those accounts involve minor children as beneficiaries. Okay, so those all add up, and again, it's gross. So on a house example, you can have $1 million house with an $800,000 mortgage. The probate fees, which are a percentage of the value, is the value of the gross value, the $1 million, not the $200,000 equity. Okay, and so what maybe on a 3 or 4% fee against $1 million doesn't sound like a ton. A 3-4% fee against 200,000. That is a lot. That is a significant portion of the $200,000 in that case. So that's where the fees can really mount up in terms of as a percentage of the overall estate, especially if there's a lot of debt involved with some of the assets.
Can you walk us through another real world example? Let's say somebody owns a $1.2 million home in Orange County and a few bank accounts. What would statutory probate fees roughly look like in that situation?
So the fees, they are graduated fees. In other words, the initial fee is 4% of the first 100, 3% of the next 100,000, and 2%, 1%, and ongoing. And so, as an example, let's say everything added up to $1.5 million. All right. Then we're looking at roughly $28,000 in legal fees, and that's a statutory fee. In other words, they can't charge more than that. Okay, and that's obviously what most attorneys will charge to do that case. And again, $28,000, is not a small amount of money, and typically unnecessary. And that's why I have a job. That my job ultimately is to keep probate attorneys unemployed. And the best way to keep them unemployed is, if you have assets like a home, is to create a revocable trust to avoid and properly fund that trust, which we talked about in prior episodes, to avoid probate and the whole process.
Well, by all means, let's keep them unemployed. So beyond attorney fees, what other costs are built into the probate process that families don't anticipate?
So one thing that, people comment out, is there a tax? There's not really a tax. Okay. The government's not really making any money on it. There's obviously some court filing fees and things like that. That's one thing. There's also probate referee fees. There's appraisal fees if you have to value stuff. And so, those are the additional fees. And compared to the probate, the legal fees, they're fairly minor. Now, those probate fees, they can go higher. All right. And so while for our standard unopposed case, the 28,000 we just talked about would be, pretty close to the number, plus the, the additional filing fees and appraisal fees, which may be a few more $1,000s above that. If people are contesting your case, if there's a legal fight going on, well, then the attorneys are going to be asking for more fees. Okay, because these are fees. This is assuming unopposed. Okay, nobody's fighting about anything. Everything is going through. There's no opposition during any part of the proceeding. Is kind of what the attorneys will charge. But if you start having people filing motions and opposing what you're doing, that in itself is going to add a lot of fees, because as soon as people are fighting about stuff, the fees really escalate.
I think you touched on this a little bit earlier, but how long does probate typically take in California? And what does that timeline mean for the beneficiaries who are waiting on access to funds?
So the timeline for most probate cases, overall timeline is somewhere between 1 and 2 years for it to resolve itself. Now, that doesn't mean you don't have access to the money for 1 or 2 years. The typical thing that happens is as soon as somebody's approved as an executor, it might take 6 weeks for somebody to get approved as executor. They now have control of the assets. Okay, once they have control of the assets, they can they can pay bills, they can sell a property, and so they can start doing things with the assets. Okay, but what they can't do is distribute the assets to other people, other than maybe maintenance issues. In other words, if they somebody needs support, especially God forbid you have minor children involved, money can be paid out to make sure those kids are taken care of. Okay, but just enough to keep them going, not inheritance, not the entire inheritance. But the overall amount of money will be tied up until that case is resolved. Taking the money out of probate will be the last step. Okay, because one of the steps is they want to make sure it's taken care of before anybody gets paid, is that the creditors get paid. Okay, or obviously anybody challenging what's being done. But as I always describe to people, probate's a lawsuit against your family. The primary goal is not necessarily to make sure your family gets money; it's to make sure the creditors get paid in an orderly fashion. And then whatever's left, if there's anything left, will then go to your family. But it does mean that to get access to the bulk of the assets, we're talking 1 to 2 years, and that's in Orange County and probably LA County too. Other counties might be a little faster because their court systems may be a little less impacted. We know other states where probate's much quicker than that. But here in Orange County, LA County, we're not one of those. Things are not fast, and they're not getting faster. The pandemic slowed things down by 2 or 3 months, and we have never caught up since then.
So let's talk about a situation where you've seen where a family assumed that probate would be simple, but the process turned out to be more involved than expected. What made it more complicated?
There's 3 things where things would get lengthened out and mostly because it's conflict. A, who's in charge? Okay. Even with a valid will, there could be where that nominates an executor. Somebody can come in and challenge that. So that would obviously draw it out further, because now we have to have a bunch of hearings, and maybe there's alleging that you as if I'm the executor, that I'm not fit to do it. Then we go into a whole proceeding of that. The second is the creditors. Again, we talked about they got to get paid. Is there enough notice being given? Does who owes money? And it might be, and it could be, debts that aren't very well documented, or improperly documented. And then it becomes issue, is there an actual debt? Or, Uncle Bob, $10,000 because of something written on a napkin. Okay. Those are kind of the classic issues. And then finally, the big issue, obviously, when there are probate cases that are being contested is, especially if, when money's going to the kids, or somebody, so-and-so was promised this, and they, they're alleging, the person, when they did the documents, didn't have sufficient capacity or undue influence. And that's why I warn my clients, if you're not going to treat your kids equally, you are opening things up to, people challenging it. And again, we can't do anything to stop that. I mean, we could, there's some things we do to maybe make it harder, or make it decrease the incentive to do so. But we can't prevent anybody from challenging what you're trying to do. And if they're going to challenge it, they're going to challenge it in court. And people sometimes don't find that out until, well, they're actually in court.
So some people believe that having a will allows their family to avoid probate. How does the will actually function within the probate system?
In actuality, the will is what's being probated. Okay. Either there is a will and that's being submitted and that's going to be probated, or there's no will at all and a will will be created during the probate process. Okay. So a will, because again, a will by itself does not empower anybody to do anything. Okay. They need the court's involvement in order for A, somebody to become the executor. Now they have authority to deal with assets. And then B, authorize, pay the creditors. And then finally, pay out what's left to the beneficiaries. And the will is actually what's being followed. Okay. Obviously, part of the process is proving the will. So eventually, as part of the process, the will be approved. But again, people have the potential to object to the will being approved, and so that'll be part of the process. But the will that's why a will by itself does not avoid probate. It is what's subject to probate. And again, if you don't have a will, then they'll create one for you.
Are there certain assets that actually avoid probate automatically? And how do families sometimes misunderstand that?
Yes. The number one asset is anytime you can name a beneficiary on an account, and those beneficiaries are over the age of 18, those are automatic. Not subject to probate, not even subject to your will or power, or even if you have a trust. That's outside those assets, because that's happening directly at the institution. As an example, if somebody, I name Uncle Bob as the beneficiary of my account, and even though I have 2 kids, if something happens to me, that money's going to Uncle Bob. Uncle Bob will go to the bank and say, unfortunately, Brian died. Here's a copy of his death certificate. And they'll look, oh, Uncle Bob, you're the beneficiary. Here's the check for the money. That's outside the will. That's outside the trust. It has nothing to do with probate, because that's outside of probate. Okay. And so that's the most common thing that would be, not part of the probate process, or automatic beneficiary designations for people over the age of 18. And the reason what people understand, they think, oh, that asset was part of my trust, or that's going to be divided up equally. Well, I guess the more common is actually, this is what we see all the time. It's not even beneficiary designations. Well, they put kids, like they have 3 kids. They put one of the kids on joint just for convenience purposes. And just in case they die, they want to avoid probate. Yes, that avoids probate. The parent dies, the money goes to the surviving sibling, that child. They think that money then goes equally to the other siblings. It does not. If that person's a joint owner, and again, that avoids probate, that's it. That money goes to them, and what they do with the money from there is up to them. Now, maybe they'll share it, maybe they won't. I don't know. But that's probably the biggest misunderstanding, is that they think if I died, this person gets the money. Yes, that avoids probate, but they get the money, which means it's not subject to any kind of probate proceeding.
Well, as we conclude today's episode, and for somebody listening who owns property in California and wants to avoid putting their family through everything we've discussed today in probate, what planning strategies make the biggest difference?
Well, as I've kind of mentioned throughout here, for most of my clients, in an effort to avoid probate, it's having a revocable living trust. And then most importantly, as I've talked in prior podcasts, funding that trust with your assets. You do that, you make it simple. And that's the goal. That's my goal for my clients, is give them peace of mind that things, the right persons will be in charge, the assets will go to where they want to go, how they want to go, and avoiding probate because they have assets like a home or minor children. The trust is typically the best way to avoid the probate process.
Well, thank you for listening to Estate Planning Beyond the Binder. Understanding how probate works and what it truly costs can help families make informed decisions before crisis ever happens. If you'd like to review your current estate plan or explore options to simplify things for your loved ones, visit ocwillsandtrusts.com to schedule a consultation. And remember to leave a review, and subscribe to the show so you don't miss the next episode. Thank you, Brian.
Thank you, Lan. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.